great colleague, and a lot of us were pretty close to Judge Fuller. So we will be in recess for Wednesday for the funeral services. I don't know, it's 10 o'clock, I think. So we should have an afternoon session rather than a morning session. So you'll have to reschedule your Mr. LeBow?
Yes, yes, sir.
Have a seat here. So if that'll accommodate your schedule, we'll figure on Wednesday morning. All right, have a seat, sir. Before we begin, we were somewhat concerned because of the nature of the facts and circumstances of this case about that global settlement issue. I understand counsel has already conferred with you on that. Mm-hmm. And I just want to remind you that those matters of the settlement or anything that relates to the settlement really are inadmissible in this trial.
Okay, very good.
Unless the court rules otherwise, and that'll determine basically the type of questions. But I just want you to be aware that you're not going to make any reference or mention to that.
Okay, fine.
All right. So, and if it does come up inadvertently in the question, stop, don't answer it, and I'll make a ruling. Okay, let's bring the jury in, please. Oh, good. Today is what? Lost track of the date. 21st already. Okay, have a seat, folks, please. Thank you. How are you folks today? Have a good weekend? Good. Did anybody watch TV, read newspapers, magazines, talk to anybody at all about this case or any of the related matters? All negative answers? All right, let's proceed then.
I do.
Good morning, Mr. LeBow. Tell the jury, please, your full name and your business address.
My full name is Bennett S. LeBow, and my business address is 100 Southeast 2nd Street, Miami, Florida.
You are the owner of Liggett Tobacco Company?
I'm a majority shareholder of Brook Group, which is the 100% owner of the Liggett Tobacco Company.
Okay. What is the relationship between Brook and Liggett?
Brook owns 100% of Liggett.
And how long has that relationship existed? I mean, basically what I'm asking you is how long you've had any involvement with Liggett.
Over 10 years.
You are the chairman and CEO of Brook?
That's correct.
Okay. And Brook owns Liggett 100%?
That's correct.
Okay. What are some of the major Liggett brands?
L&M, of course, which stands for Liggett Myers, Chesterfield, Lark, Eve, Pyramid, and discount brands, many discount brands.
About how many discount brands do you have?
In excess of 100.
In excess of 100?
Yes.
In terms of the major brands like L&M and Chesterfield and Lark, are they characterized as premium brands to distinguish them from the discount brands?
Yes.
What is the basic price differential between premium and between discount?
Well, it varies from state to state, of course, but it's about 70, 80 cents a pack, some number like that, approximately.
Mr. LeBeau, does cigarette smoking cause lung cancer, heart and vascular disease, and emphysema?
Yes.
Let me object to that question, in as much as there's been no foundation laid of this man's medical or scientific expertise. He's asking for an opinion.
I'm asking him the question, Your Honor, as the owner of Liggett.
Well, that still doesn't... I'll sustain the objection. Lay a predicate of some sort, please.
Since your involvement with Liggett over the years, and since you've been the owner of Liggett, have you had occasion, particularly in more recent times, to focus in on issues relating to smoking and health?
Yes.
Have you directed your lawyers to review a tremendous amount of tobacco documents, not only Liggett documents, but the documents of other companies, to assist you in reaching a determination as to whether cigarette smoking causes disease?
Yes, new counsel we hired back in December of 1995 have now focused on that to a great degree at my direction.
And as a result of that analysis and review, have you reached certain conclusions on the issue as to whether or not cigarette smoking causes disease?
Based upon that review and certain...
Yes or no, please. I'm sorry, Your Honor.
The question calls for whether you've reached a decision, yes or no.
And then
Yes.
Okay, and explain your answer. Based on
Objection,
what?
Your Honor. There's still not a proper predicate. All we have here is
This is his personal opinion based upon his review of the document that he asked his employees to prepare.
Yes, sir, and to that we object because he is not qualified as an expert.
Well, he's not here as an expert, no.
Yes, sir. We object.
Overall. Let me answer the question.
would you repeat the question, please?
Did Your Honor say he answered the question?
Yes,
already?
you may answer the question.
Oh, he may answer it, okay.
I'd like to repeat the question, please.
You may read it back, sir.
Question: as a result of that analysis and review, have you reached certain conclusions on the issue as to whether or not cigarette smoking causes disease? Based upon that review? Answer: based upon that review. Mr. Moss, yes or no?
Okay, that's the question.
Explain your answer. Based on what?
The answer is yes, we have reached certain conclusions.
Okay. And to get back to my original question, does cigarette smoking cause lung cancer, heart and vascular disease, and emphysema?
Based upon the review of these certain documents that my attorneys reviewed at my request, and based upon my own layman's knowledge of what I see in the popular press and the various reports I read about and my own personal feelings, the answer is yes.
Is cigarette smoking addictive?
We believe for many people...
Same objection, Your Honor.
Same ruling. No rule.
Again,
Is cigarette smoking addictive?
again, based upon the same sources of information, yes, we believe for many people smoking cigarettes is very addictive.
Now, Mr. LeBow, I took your deposition way back on November 5, 1993, where I asked you similar questions about whether smoking causes disease and whether smoking was addictive. And at that time, your answers were different. Is that correct?
That's correct.
Back in 1993, when you were asked those questions by me, you took the position that cigarette smoking did not cause lung cancer and other diseases, and that it was not addictive, correct?
I believe we took a position I didn't know about the health aspects of it. On addiction, I said, yeah, I believe at the time that on my own personal level, because I had my own personal experience go by only then, that I thought smoking was not addictive because I had quit 20, 30 years ago. But after reviewing it, since that time, reviewing all this new information and really studying the popular press and what everyone says, we've come to totally different conclusions.
And as a matter of fact, have you said in various public forums that you now admit you've changed your earlier position and you now admit that cigarette smoking does in fact cause lung cancer, heart and vascular disease, and emphysema, and that it is addictive?
That's correct, we have.
Can you tell the jury what reaction your fellow tobacco executives had to your change of public position on these issues?
Objection, Your Honor, it's hearsay.
Well, without getting into hearsay, or the truth of the matter asserted, I think he can testify as to what a reaction would have been overall.
I didn't have any direct, reaction from any tobacco executives because they don't talk to me these days. But from what reported in the popular press,
Excuse me, Your Honor. I mean, we now have hearsay upon hearsay.
I haven't had any hearsay yet because he said they don't talk to him.
No, but he said according to the popular press. That's
Okay, as it may
hearsay
relate to the
upon
press,
hearsay.
I would agree with you. Okay.
From any source, Mr. LeBow, I'm asking you if you've learned from any source, from your attorneys, from any aspect, from conversations with other executives, what the reaction of the executives of Philip Morris, Lorillard, and Reynolds has been to your public admissions.
Objection, Your Honor. We're now. The witnesses testified that he had no discussions with the other CEOs in which this question goes.
I think I'm going to sustain the objection. I think what we have to do is determine what the source is before we ask what the evaluation of that source information. So let's find out what the source is first.
From what sources have you learned the reaction of the other tobacco companies to your public admissions?
from my attorneys, primarily.
And what have they told you?
Objection, Your Honor.
No, I'll sustain that.
Has any tobacco company offered to pay and actually paid for your legal fees in defense of certain tobacco litigation?
Your Honor, may we approach the bench?
Yes, sir.
Mr. LeBeau, isn't it true that Philip Morris has offered to pay your legal fees and has in fact paid some of your legal fees in connection with tobacco litigation?
Objection, Your Honor. Lead.
I'm on cross.
Adverse type witness.
The answer is yes.
And tell us about the circumstances of that.
In late '95,
Object, Your Honor.
Overruled. Circumstances, overruled.
in late '95, the attorneys that we were using, that Liggett was using for outside counsel and tobacco litigation, wanted to go to another law firm, and they asked for our permission, and we said, no, we would rather you go to our law firm, a different law firm that we use. And they came back and said, if I let them go to the law firm they want to go to,
Your Honor, I have a problem. This is all hearsay. How can we cross-examine?
Let's have a sidebar. Folks, why don't you step in the jury room for a few minutes, please? I think what we better do at this point is voir dire the witness on certain issues.
May I do that then?
Well, either of you might. I don't care, really. I mean, I'd like to know what the questions are, and then,
I guess normally,
if there's a pending question, which there was,
right.
why don't you do that? But I want to know basically what the area is he wants to cover, so we don't run into problems. So if you want to start, that's all right with me.
Well, if he tells us what the areas are he wants to cover.
That's what I wanted
Then
to
I
do.
can do the voir dire.
So ask a few of the questions that you're talking about that may relate to this kind of an objection, and then we can work it from there.
Well, the bottom line of my question was to ask Mr. LeBow to make the point that obviously Philip Morris did not pay his legal fees out of the goodness of their heart, and from his standpoint as a very sophisticated businessman, the owner of a tobacco company, why did they do that? Without
There would be an
relating,
objection to that.
without relating specific conversations. What's his understanding as to why they made such a generous offer? Did this ever happen in your history before, Mr. LeBeau, where some competitor offered to pay your legal fees?
Mr. LeBeau, did you have, let me ask you this. Any information that you would have with regard to the issue of someone else paying Liggett's legal fees would necessarily be gained by you from conversations that you had with others, am I correct?
That and documents presented to me to sign.
The documents presented to you to sign. Do you have those documents with you?
No.
Did you review those documents,
Yes.
or did your counsel review them?
Both.
But other than the documents that may have been given to you to sign, which you don't have, anything else, any knowledge, any other knowledge that you have on this issue would be the result of conversations that you had with others?
With my
Or others in your behalf had with others as well?
conversation I had with my attorneys.
Thank you. And based upon that, Your Honor,
I will sustain the objection based on that, yes. You'll have to do a little adjusting on your questions, I guess.
Well, I think, Your Honor, if he was presented with documents to sign in the ordinary course of his business affairs, that would be admissible as to an offer on the part of one of the co-defendants to pay his legal fees at a time where they were obviously concerned about what he was going to say and what he was going to do.
The
That's
point
not
is,
hearsay.
the testimony is out already that somebody made the offer, okay?
Correct.
Now, the question that was asked was, why did they do that? He's got to put himself in the minds of others before he can answer the question, which is prohibitive. The second thing is, if there is a document that relates to that, then the document would have to be here. So
Your Honor,
we don't have that either.
there's an additional ground. And,
Well, I don't know if it's really necessary at this point.
well,
You had to come up with it.
I think it is, Your Honor.
All right, go ahead. Put it in the record.
This is section 90.502 of the Florida Evidence Code, and I quote, Section 90.502 codifies the pooled interest privilege. If a client's lawyer communicates with a lawyer of a co-party, it would be a privileged communication under Section 90.502, parent 2, close parent, since the lawyer made it during the rendition of legal services to the client. Clearly,
Well,
this is
We're not,
exactly...
I'm not so sure we're in that stage yet. There may have been adverse issues there, which would take it out of the purview of that.
Well, there may have been,
But,
but there's been no testimony or record of that, sir.
Well, that's one step beyond where we are, frankly.
Well, Your Honor, I think the witness could then be asked, did he accept the offer to pay
Oh,
his
yeah,
fees?
he can be
Yes
asked
or
that
no, if he did for a while, why? If he didn't, why not? And why didn't you?
That's a
Yeah,
different story.
that's-
His motivation is something different than somebody else's motivation.
As the CEO of Brook and as the controlling factor of Liggett Tobacco Company, he can't go into the minds necessarily of why the offer was made, but he can certainly go into his mind as to why he accepted, why he rejected what he did. And that's going to be the next line of inquiry.
Well, Your Honor, that's why we read to you that section of the code which makes those conversations privileged and those matters privileged. That's exactly the reason we raised 502.
The interests aren't adverse at that point?
No, sir. Well, Judge, obviously, if the interests are adverse at that point, what in the world is he doing talking about cooperating in legal services? They're obviously not, and he hasn't laid a foundation, and that's exactly the position and reason we just...
Well, where I'm going with this is, Your Honor, that was a means of buying his silence and his cooperation, so he would not be a public spokesman for the opposite position.
I'll let you develop that issue at that point. Okay, I think you have to develop that before you can get into asking the question. So we'll see where it goes. All right, let's bring the jury back out.
Your Honor, just for the record,
Whoops.
I actually do the relevance objection. You're starting down this line of inquiry and as I understood it, you overruled the objection based upon counsel's statement that this goes to the witness's credibility. We're now well beyond any suggestion by them that they're trying to show credibility of this witness, and I therefore renew the relevance objection to this whole line of inquiry.
I think it still goes to credibility overall. All right. Okay, proceed.
Mr. LeBow, did you accept the offer of Philip Morris to pay your legal fees?
Yes.
Why?
At the time, I was very busy on other things, and they're offering to pay a lot of money. We're paying, rather being charged at the time, somewhere under $10 million a year. But
in,
it really,
in legal fees?
in legal fees from all the firms, and Phil Morris offered to pay all this.
Had that ever happened in your experience before, where a competitor offered to pay all your legal fees amounting to some $10 million a year?
No, never happened before.
There was an objection. Overruled.
To your knowledge, were there any strings attached to the $10 million?
Objection, Your Honor. We're now
Can I get two questions?
No, you can't get two questions.
Just a moment. Gentlemen, please, don't talk to each other, okay? Talk to the court.
Your Honor,
Okay.
you've already, it's hearsay, Your Honor. We've already established the
Well-
basis of his knowledge. He's now asking, he's already said, I never spoke to anybody about this.
I understand, but I think he's now talking about his mental impression.
No, that wasn't the question. If that's
thought it
his
was.
mental impression, that.
Let's hear the question back, please.
Question: had that ever happened in your experience before, where a competitor offered to pay all your legal fees, amounting to some $10 million a year? Answer: no, never happened before.
That's not the question.
Yeah, next question.
Question: To your knowledge, were there any strings attached to the $10 million?
That's to his knowledge, overruled.
But his knowledge,
To your knowledge, were
To
there,
his knowledge. His knowledge may be right, may be
gained.
wrong. This is coming in for, not for the truth of the matter asserted, but merely that it was asserted, or at least he knew about, or at least he thought about it. If we get any further than that, then we get into a different story.
Yes, there were a couple strings. One of them was that this group of lawyers that Liggett had used for the past 40 years could only go to a certain law firm that Philip Morris designated and work out of that law firm. Was one string. And also, they had the right to cancel the agreement upon 30 days' notice at any time.
how long did you accept Philip Morris's offer to pay your legal fees? How long did that last?
We accepted it for a while, but they canceled after about 5-6 months.
So, right now, they're not paying your legal fees.
That's correct.
For what reason did you ask your counsel to review documents not only of Liggett, but of the other tobacco companies as well?
Your Honor.
Counsel, I understand we got a little problem here, so let's talk about this sidebar for a minute. Okay, when we first talked to you folks about this case, I told you that during the course of the trial there'd be some procedures which would be sort of impractical. One of them was that we would do a lot of talking without you being present, lawyers and I. We're at that stage, and I think you sort of understand. We've got to do a lot of talking, but we can't hardly do it over here, sidebar, effectively. I'm going to have to ask you to go back in the jury room again. Please bear with us. These things are unavoidable. Okay. Now, have a seat, folks. All right, Mr. LeBow, you've had time to confer with your counsel.
Yes, Your Honor.
Are you ready to proceed then?
Yes, we are.
Good. You're not waiving? Okay.
But I think it should be clear, though, that the attorney is asserting the attorney-client privilege, therefore he's not answering, as opposed to the jury having the misconception that you sustained an objection, that somehow this was objectionable testimony. I think that should be clear, as it would ordinarily be in the course of the trial, otherwise we're prejudiced.
Your Honor, I've never heard of a rule that the court needs to explain why a question can't be answered other than the fact the judge sustained the objection. The objection was what it was, and you sustained it.
Mm-hmm.
I mean, we've got a different set of rules when a party is asked a question that calls for a different type of an objection. They haven't done that yet.
I'm not asking for an instruction to the jury, I'm just asking in the normal course of events, counsel would state, we assert the attorney-client privilege, and then the objection would be sustained. We don't feel it's privileged, you overrule our objection, but, you know, basically, I think the way it's left hanging right now, it's very confusing.
I don't think it's...
Well, generally, it would be an objection. It might be one-word answer or privilege, and we have a sidebar conversation with it and come back and then change hands. All right, we'll just sustain the objection at this point and let it ride. Bring the jury out, please. Oh, I'll tell you what, hold them off for 1 second. Just one more time. We were going to, if we're going to go beyond this area, I thought we would discuss the next area so we don't have to send them back and forth all the time.
The next areas, I think, are relatively non-controversial, Judge. I don't like to, you know, these guys
Okay.
are all so sharp, I don't want to tip my hand too far in advance.
Well, you did say you'd lay it all out.
That was before a ruling. All right, then bring the jury in. All right, folks, have a seat, please. Thank you. All right, let's proceed.
Mr. LeBeau, this is one of your products, right?
That's correct.
L&M.
That's correct.
Now I'm going to show you Plaintiff's Exhibit 774 and ask you about a particular warning which appears on this package of L&M, which says, warning, smoking is addictive. Shall I hand it?
Yeah, this is marked already in evidence. What's the number, 774?
Your Honor, for the record, we do have objections to the admissibility of the exhibit.
Overruled.
Okay, you got it in
Yes,
front
I
of you?
do.
Okay, now the words, warning, smoking is addictive, that is not one of the 4 warnings mandated by Congress that every tobacco manufacturer must rotate on its packages, correct?
That's correct.
This is something you've voluntarily done, is that correct?
That's correct.
Does that appear, other than on Liggett products, to your knowledge, is that admission or warning contained on any other package of cigarettes anywhere in this country?
Not to my knowledge, is it?
Now, Mr. LeBeau, the 1986 Surgeon General's report is in evidence in this case as Plaintiff's Exhibit 887. And the first major conclusion of United States Surgeon General Coop on page 7 is as follows. Involuntary smoking is a cause of disease including lung cancer in healthy non-smokers. Assuming that the Surgeon General of the United States said that in 1986, you'd have no reason to quarrel with that or disagree with it, correct?
Objection, Your Honor, there's no foundation. Secondly, this is an improper use of the document that is in evidence. And, there's no qualification been made of this witness.
I really don't want to get into a speaking objection.
Well, I just...
We may have to discuss it again, sidebar.
Well, I think those are the...
Hello? Clerk? Clerk? That's a physical. I don't.
Let's get the record clear. There was an error regarding the 744, I think that's the number of it. 774. Okay. And 774 was not in evidence, which we had thought it was. It is not in evidence at this point. Mark it for identification purposes. Okay. Okay.
Mr. LeBow, when you're advised that the United States Surgeon General has reached certain conclusions on issues relating to smoking and health, you don't have any basis or scientific background to disagree with those conclusions, do you?
No, that's correct.
And that would also be the same relating to conclusions reached by the United States Environmental Protection Agency. You would have no basis to disagree with their conclusions, would you?
That's correct.
And you, based on what you know about their conclusions, you don't disagree with them, do you?
Objection, Your Honor. That's the same question that we're up there on.
He personally needs to state his own personal opinion. Overall.
Repeat the question again, please.
Based upon what you know from a variety of sources about the conclusions reached by various Surgeon Generals over the years and by the Environmental Protection Agency, you personally don't disagree with their conclusions, do you?
That's correct.
Now, Liggett sells its products in countries other than the United States, is that correct?
Another subsidiary that we own sells products overseas, yes.
Okay. Now, talking about Russia, for example, have you required Liggett to put on certain warnings in Russia which are not required by Russian law?
Your Honor, this is exactly what
That's a different story. I think we're outside an area. Overrule the objection as it relates to that question.
you also object to relevance.
Overrule irrelevant.
We haven't as yet, but we are seriously studying the issue and plan to do that if possible, subject to Russian law.
have you had occasion to testify before the Massachusetts Department of Public Health relating to issues involving smoking and health?
Yes.
And tell us in a general way what position you took or what level of cooperation you gave to the Massachusetts Department of Public Health.
The Massachusetts Department of Public...
The objection is as to relevance. Second.
Overruled at this point.
The Massachusetts Department of Public Health is promoting rules which require cigarette manufacturers to disclose all the ingredients in their cigarettes, all the additives, all the types of tobacco, et cetera, et cetera. We went up there and testified that Liggett is prepared to do this, that we are going to disclose all of our ingredients on all of our cigarettes, sometime in the next few months, and we have absolutely no objection to the rules that the Massachusetts Department of Public Health is promulgating.
Do you know what position the other tobacco companies took with respect to that same issue in Massachusetts?
Objection, Your Honor.
I'll have to sustain it on the basis of that question with no predicate.
I want you to assume, Mr. LeBow, that in April of this year, just a couple of months ago, I took the depositions of the CEOs of Philip Morris, Reynolds, Lorillard, and Brown and Williamson. And when I asked them...
Excuse me, Your Honor. Before we get to a point where Your Honor has to give a period of instruction, this is a problem.
No, come over here. It's not like TV, is it?
Mr. LeBeau, is Liggett and Brook cooperating with public health officials at the federal level, the state level, and the local level relating to questions of health?
Yes.
To your knowledge, or any of the other tobacco companies so cooperating?
You know,
Same
and I
objection,
apologize
same,
for having,
just a minute.
but you ruled on this.
I
No.
agree. They were talking about Massachusetts, now he's talking about federal and other states.
This,
And that makes the difference, but it's the same ruling. Overruled, sustain the objection.
Mr. LeBow, based on the documents that you've reviewed, based on your knowledge from any source whatsoever in terms of your recent focus on issues relating to smoking and health, is there any, in your opinion, is there any legitimate debate on the issue as to whether cigarette smoking causes lung cancer and other diseases?
Objection, Your Honor. Through this before.
Well, there's different areas we're talking about now. We're talking either lay or scientific or
Talking lay.
Well, there's been no foundation, Your Honor.
within the
And a
industry.
lay opinion, you can't give a lay opinion as to an area of expertise.
In that regard, I would agree. If he narrowed it down to within the industry, he might. Okay. Overrule as the court indicated, if he's talking about within the industry. Otherwise,
Now, I'm talking within the industry on behalf of Liggett and Brook as the owner of Liggett, as the CEO and chairman of Brook. In your opinion, is there any legitimate controversy whatsoever about the fact that cigarette smoking causes lung cancer and other diseases?
There should be absolutely no...
well, overrule the objection on that question. Go ahead.
No, there is no controversy whatsoever from our point of view.
And anyone who's been following that issue should know that, correct?
Objection, Your Honor.
Sustain that argumentative.
That's all I have.
Cross?
Not giving us a quick break.
All right, you'll need 5-10 minutes.
All right, let's take 10 minutes, folks.
Just wait a minute.
Okay.
All rise. All right, are we ready to proceed? Yes, sir.
Yes, sir. All right. Bring the jury up.
Bringing in the jury.
I gotta go see the eye doctor again. Getting me ridiculous. My eyes are tearing, itching. It must be allergy, but have a seat, folks, please. All right. Cross?
Yes, sir. Good morning, Mr. Bell.
Good morning.
I think I'm not sure we met, but I think the one time we did was back at your deposition in November of 1993. I assume by now you've forgotten a lot of that.
I've forgotten you.
All right. Which is really not a bad idea. Let's see if we can establish a few things, sir. Is there any question that exists in your mind that you are not a scientist?
No, no question.
No question. You're not.
I'm not a scientist.
Don't claim to be. Don't profess to be. Not trying to tell this jury that you're a scientist.
That's correct.
And you're certainly not trying to tell this jury that you have any training in medicine, that you have any expertise in matters of medicine or medical knowledge, correct?
That's correct.
Never had any training, indeed.
That's correct.
Now, just as you don't claim or possess any expertise in science or medicine, you clearly do claim to be first, last, and foremost a businessman, right?
Amongst other things, yes.
You are certainly not claiming to have any medical or scientific expertise in the scientific or medical area or specialty known as medical causation, and in particular with regard to cancer causation. Is that correct?
That's correct.
And as to claiming any expertise or special knowledge, special training, special education, you are not claiming to have any of those special areas of knowledge as it relates to issues of addiction.
That's correct.
And when I talk about addiction, do I understand that you don't claim to be an expert or have knowledge based upon education in areas of dependence and habituation or habit?
I'm not an expert.
And are not claiming to this jury to have such expertise, correct?
That's correct.
And with regard to those issues, I want to be sure, the issues being medical causation, cancer causation, addiction, dependence, and habituation, you have not made any scientific studies of that, have you, sir?
No, I have not.
Now, with regard to, Mr. Rosenblatt asked you some questions about whether you disagreed with some statements or conclusions of the surgeons general in the reports of 1986 and 1988, correct?
I believe those are dates. I'm not sure the dates you used.
And you indicated that you had no reason to disagree. I think that's the line of it. You remember that?
I remember that, yes.
Now, as a matter of fact, or at least as a matter of fairness or completeness, you have no basis yourself, based upon your training, knowledge, expertise, to agree or disagree. Is that correct, sir?
I have no specialized training in those areas, no.
Well, sir, let me ask you this. Is it fair to say that you have never yourself read a Surgeon General's report?
I've recently glanced through some of them, yes.
How recent?
6 months, a year ago.
And the reason I'm pausing here, Mr. LeBow, is because of the statement that you previously made in a deposition. This was a deposition, it's the deposition of Bennett LeBow taken in this case on June 24, 1997, less than 30 days ago. And perhaps we're just arguing about terms or let me ask you if you remember being asked this question and giving this answer at page 145. Question, have you ever read any Surgeon General's reports? Answer, No. Remember giving that testimony? You want to see it?
No, I believe you.
That's.
I've read the newspaper reports of the Surgeon General reports.
So. Other than newspaper reports, then your testimony a month ago is still quite true. You've never read a Surgeon General's reports. You may have read some newspaper accounts of them.
Yes, I've never read the exact report.
Well, you've only read the newspaper accounts, if I'm
This
hearing you.
newspaper summaries, that's correct.
Okay. Now, Mr. Rosenblatt referred to some prior testimony that you gave back in the end of November of '93 in a deposition he took. And what I want to ask you, sir, is that when you testified at that deposition, in this case, November of '93, that you did not believe smoking was addictive, and that you also testified in that deposition that quitting was a matter of willpower as far as you are concerned. Was that a belief that you honestly held when you gave that testimony?
It was a belief based pretty much just on my own personal experiences, not on any other documents or facts,
I
which I've seen
understand that.
since that time.
My question, sir, was that a belief? Were you under oath in November of '93?
Yes.
All right. Was that a belief, the one I just read, that you honestly gave then?
Regarding my own personal experiences, yes.
Okay. Well, you couldn't give the belief of anybody else.
Correct.
All right. Now, also, sir, when at the same deposition, when you testified in '93 that you did not believe it had been medically established that smoking caused lung cancer, but you also said you surely recognized it was a risk factor. Was that a belief at the time that you honestly held, sir?
At the time, yes.
Now, you've had a change of opinion
Yes.
yourself, right? And you've testified to that. And that change of opinion occurred only earlier this year. Is that correct, sir?
It's occurred over the course of the past year, yes.
Okay. The change of opinion occurred during this year. That's all I'm asking.
I'd say it was building up since '93. I wouldn't say it just occurred one day in the past year, but it's a combination of many events happening over the past 3 years.
When did you go public with that change of opinion? When did you tell the public about it?
About 3 months ago, 4 months ago.
Did you tell the public about that at any time before that?
On a public basis, not that I'm aware of, no.
That's all I have.
Anybody else? Yes, sir.
Mr. LeBow? Mr. LeBow, are you proud that Liggett and Brook have changed their position on smoking and disease?
Yeah, very proud. I believe we absolutely did the right thing. We do it again in a second.
And Mr. LeBow, are you proud that Liggett and Brook have changed their position on smoking and addiction?
Absolutely. It's something we really believe in.
Thank you very much.
Redirect?
Yes.
Mr. LeBeau, you are not a scientist, but you have more than a passing interest, don't you, in issues relating to smoking and health?
That's correct.
You consider that your own wife, who's a smoker, would like to quit and she can't, then you consider the fact that she's addicted to smoking.
Objection, Your Honor, this is well outside of the scope.
Questions?
Excuse me. It's well outside the scope of my cross, and it's also a matter that is not relevant to this case, Mr. LeBeau's wife and her habits or not.
Well, I would agree that it's outside the scope of your question. It may not be outside the scope of Mr. Fay's question. I'm not so sure that we're in the area we're supposed to be in regarding his personal life and family.
It goes to this question of addiction.
I know, but
and how he forms his
On
personal
his own personal
opinions.
basis.
He's made a judgment about his wife.
I understand what you're saying, but on his particular personal experience, nobody ever mentioned his wife. So sustaining it as it relates to his wife, he can talk about his own personal experience.
You used to be a smoker.
Correct.
You quit 27 years ago.
Correct.
Have not gone back to it, right?
That's correct.
Because you didn't think it was a healthy habit
That's
or addiction, correct?
That's correct.
You've got children, you've got grandchildren, you want it to be around as long as you possibly
Your Honor.
could, correct?
Your Honor.
Argumentative, I was just thinking.
Now, the deposition that Mr. Morse referred to that was taken June 24th of this year, of course, this trial began June 2nd. I was not the guy taking that deposition, was I?
That's correct.
The lawyer taking that deposition, who grilled you all day long, was from what tobacco company?
Your Honor.
All right, let's have a sidebar.
Is all of your testimony here today and all of the opinions that you've expressed on behalf of Liggett and Brook?
Yes.
Isn't it a fact, Mr. LeBow, that when you were giving testimony in November of 1993, and you denied that cigarette smoking was addictive, and you said it hadn't been scientifically established that cigarette smoking causes cancer and other diseases, that at that time you were simply spouting the accepted tobacco party line on those subjects? Isn't that a fact?
That's a fact.
And that was part of the litigation strategy of Liggett back in '93 and all the tobacco companies, that you could simply never admit those things, correct?
Correction, Your Honor. One, can't talk about the strategy of my client or it's somebody else. He wants to talk about what Liggett's strategy is. Number one, it's not the cross of anything, but if he wants to talk about Liggett's strategy, that's up to his lawyer.
In 1993, when your deposition was taken, you were then the CEO and chairman of the board of Liggett as well as Brook?
I don't recall exactly what my position was.
Okay, because you have a lot of corporations.
Right.
Okay. Now, were you aware back in 1993, as a result of your involvement with Liggett for over a decade, that there was in fact a general litigation strategy of the tobacco industry?
Objection, Your Honor. We've just been up there. And
No,
argued.
this is...
Excuse me, I'm talking.
Please.
They don't lecture in front of the
minute.
jury.
Your Honor, we
Don't address
We have-
each other. I've talked to you about that before.
we have made
If
an
you're going to make an objection, give me a one-word objection.
objection that's outside the scope, and we just
Outside the
argued.
scope, and I'll sustain the objection.
When you were answering questions in 1993 at your deposition, were you espousing the litigation strategy of Liggett and Brook?
Yes.
And did you know that that was part of a broader strategy at that time and at this time?
May we
Did you
approach
know
the
that?
bench, Your Honor?
I'm going to sustain the objection as to what he felt, what he thought. I'm sorry. I said sustained, and I meant overruled. He can testify as what his belief was.
Your Honor, this is his,
That's what I said. It's his belief, overruled.
but this is the
Well,
same.
you-
No, it's not. It's something different.
As to your belief in 1993, the litigation strategy that Liggett and Brook was espousing in terms of the answers you gave in November of 1993, was it your belief that that strategy was part of an overall tobacco industry strategy at that time and at this time?
Objection, Your Honor.
Overruled.
Yes.
Now, Mr. LeBow, although you may not be a scientist, as Mr. Moore stated on cross-examination, is it accurate to say that you made it your business as the #1 individual in your company to learn all the facts and to get to a clear bottom line as to whether your product causes cancer and other diseases?
Yes, I did.
And did you do that?
Yes, I did.
And the answers you gave today are based on that analysis and review?
That's correct.
Thank you very much.
All right, you may step down. What's next, please?
We have the exhibits to Mr. Morgan's deposition that were presented the videotape deposition we wanted to put into evidence. I don't know if there's any objection. If there's not, we could just publish those now. The exhibits to the deposition that was shown to the jury Friday afternoon. We had waited on that because there were live witnesses.
Your Honor, there are no objections to several of these exhibits. You've already ruled several don't have been. I don't know what list with
Okay.
Maybe the thing to do would be to break.
Well, you can look at it, and we can talk about it in the break time. I don't want to take up jury's time on that.
Exactly.
What are you going to put on now?
We had anticipated that the testimony would be a little longer this morning. So
A lot
we have a witness that's coming to our office. He's probably arriving at the airport, Dr. Staples. We had anticipated for the morning. We have depositions to read, unless we could present Dr. Staples this afternoon, and that's a matter to take to defense
Well,
counsel.
you're still throwing me a curveball. We have generally another hour before a lunch break. You got anything you can fill the hour with?
We have 2 depositions to read, but there are objections, so those have to be ruled on.
I see what
So
you're saying.
the
You haven't
answer
gone over it.
directly is no, we really don't.
We gave them a list this morning of what we intend to read from
Okay.
William Campbell and
Well-
James Johnson.
Maybe I better confer with counsel on that, figure out where we're going. So let's take another one of those rest breaks. Do not discuss the case or reach any conclusion. Let me see it first. Did you make a list of the objections, the areas,
We have.
or did you just color code it?
Are we referring to the exhibits to Dr.?
No, the deposition. Got to
We
go to
had
the.
designated it, I haven't color coded it, no, we had designated Friday the depositions, we then narrowed down some
Okay.
of the areas of testimony.
Well, let me take a look at it and see maybe we can resolve it and get that over with.
Your Honor, the problem I have is that on late last week, entire deposition of Mr. Johnson was designated. We were beginning to work on that. We received this morning a list of designations just this morning from plaintiffs, which I sent back to our office, and they are now working on to determine objections and cross designations. We hope to have that back here at the noon hour, Your Honor, but I didn't expect that we were going to have to do it at 11 o'clock. I don't know.
Okay.
We have
It would have been nice for someone to tell us. I mean, going by the experience of last week, we certainly figured that Mr. LeBow would go past him in that. It would have been nice for someone to advise us, since they're into 48-hour rules, that the cross-examination of Mr. LeBow was going to take about 10 minutes. That surprised us.
Judge, let me.
That surprised
Well, it may have surprised you.
The objections didn't surprise
Wait a
us,
minute,
but-
gentlemen, please. Gentlemen, I don't want to get into
Let
it.
me simply respond.
I don't have or need for a response. Okay. What we're going to have to do is anticipate, okay, which is what lawyers are supposed to do. And if it doesn't work this way, something else is going to have to happen, so be ready. So the problem is that we run into this problem about the depositions and the areas that we want to go into as far as the objections are concerned. I suggest that since there are so many depositions that we have to go through yet, that somebody get on the ball and start going through that real soon so that we can get all of that laid out before it comes up in the course of a trial where we have to take time off for you folks to review it all. Now, I don't mind doing it myself as long as I know that we're ready to discuss it, but we're not, apparently. This is going to take more time and more time. And I'm not working on it per diem. I don't know if you all are, but I'm not.
Your Honor, we have a witness, and let me explain what's going on for this afternoon. We had designated that Monday afternoon we would be calling Dr. Staples. Dr. Staples is from Shands University, Florida. He was supposed to arrive
All right.
about 11:30.
All right.
Now, I did indicate to Mr. Hardy yesterday when we spoke that we anticipated that Mr. LeBow, we cut out 90% of the question. He would go all day, and so we said, probably he will not be on till Tuesday. Now, I asked David earlier, I said, he'll be here, we'll put him on this afternoon. That would be
Okay, I have no
fine.
problem with getting him on this afternoon.
Well, the defense
Your
does
Honor,
apparently.
Your Honor, Mrs. Rosenblatt told me yesterday that Dr. Staples was 100% certainty for Tuesday morning, that I could cancel him for today. She asked me 10 minutes ago if we could put him on the stand. I said, no, we don't have our materials on Dr. Staples. I thought he was going on first thing tomorrow. That's what you told me. Now, I don't mind I mean, I understand we have to make adjustments, but surely not with witnesses of this import. We get what amount to notices of an hour or something as to when somebody's going to stand.
Friday morning, we had said he would be on Monday afternoon, only because there was such an extensive amount and area of inquiry, and we did not anticipate that so much of it would be taken out, that LeBow was a very short witness. So he is available, and we had thought that the preparation would have been done.
What preparation do you need at this point? You had the whole weekend to prepare, and I'm sure that some of you did. You knew that was coming up, LeBow was coming up, you knew that there was going to be a possibility that he wouldn't take all day, and you knew that, what's his man's name?
Dr. Staples.
Stapleton, whatever his name is, would be the next witness, so you prepare for the witness.
Your Honor, we were given on Friday a list of some 30 exhibits that were going to go with Mr. LeBow. And all that time preparing. This morning we learned there were no exhibits with Mr. LeBow. I'm not criticizing them, but the result of that is where the focus is. On Sunday, yesterday, Mrs. Rosenblatt, I'm sure with good intention, said to David, because I had a conversation with him right after that, that you can, Staples is 100% sure for Tuesday he won't be on tomorrow. Based upon that,
The problem is there's seven or eight witnesses scheduled for this week, and so depending on when we are told people are going to be called, that's who we prepare for.
Yeah, but it's not as if you folks didn't know what's going on in this case in 6 years. You know? I mean, it's not as if this happened yesterday or the day before. It's been 6 years in the making. And you've already taken the depositions. And by God, you ought to know what's going on. Put them on this afternoon. Okay? We'll take a recess. Well, let me get the jury out. I might as well send them to lunch while we do this. It's no big deal.
Bringing in the jury.
Okay, folks, as sometimes happens, all the plans that we make regarding scheduling run into problems. We run into another one of those scheduling problems. And the next witness isn't due until this afternoon, 1 o'clock. It's only 11. Gives you a 2-hour lunch break. I'm not as happy about it either. You know? But there's not much we can do except look at each other, but that's really not going to make it. So why don't you go ahead and take your 2 hours, whatever it is you need to get done. And we'll be back here at 1 o'clock. Do not discuss the case or reach any conclusions.
They will meet in the second floor.
Yeah, I guess. Second floor, usual routine. Second floor, 1 o'clock. That'll give you 2 hours between now and 1 o'clock to review whatever deposition testimony you have to review.
Your Honor, if you want to use this time, I'm prepared to argue Morgan exhibits.
Which Morgan's exhibits? We can get that out of the way, it's all right.
Yeah, I mean, I could, or maybe what I could do is just defer to Susan, see if she wants to offer.
You all may be seated. Thank you, folks.
Well, we need to make sure the witness is coming to our office.
Well, send
Yeah, Robin's already on.
Robin out. She's already here. Send her out.
Because what I just have the exhibits that were used for the deposition itself,
Yeah.
which was read. There were a number that you sustained objections to the testimony. There were a number we don't object about, and I think it's
And some of that research, but in the area of secondhand tobacco smoke or primary tobacco smoke, I have not done any research in that area. Thank you.
And at the time of your deposition, Doctor, you hadn't really reviewed much in the way of scientific literature on smoking and disease or environmental tobacco smoke and disease, had you?
Well, you have two parts to that question. One is primary smoking, and the second was secondhand smoking.
Okay.
I had reviewed a large amount of data on primary cigarette smoking. As of that time, I had not reviewed a great deal of secondary tobacco smoke. However, it was my opinion at that time, and it still is, that it causes the diseases that we have discussed this morning.
Sure. Okay. Are you aware of reports in the scientific literature that asbestos exposure, both alone and in combination with other things, is a major cause of lung cancer?
Especially in combination with cigarette smoking, asbestos is a carcinogen.
And are you aware of scientific literature reporting that it is a major cause of lung cancer without cigarette smoking?
Now again, there are several parts of that question. One is major and the other is lung cancer. No. Asbestos is not a major cause of lung cancer in this country. It may be a cause of lung cancer, but by far it's a small percentage, very small.
Okay. And what about diesel exhaust fumes? What do you know about that from the literature?
I don't know that that's a carcinogen.
And radon exposure occurs in the homes. You said uranium mines, but people get exposed to radon in their homes throughout this country, don't they?
Yes, they do.
I wanted to ask you, just to clarify a few things. When you were showing the tissue examples to the jury to show them the disease process, let's take them one at a time. The emphysema specimens that you showed them, let me back up a minute. Are those teaching specimens that you have? Is that what you use them for ordinarily?
That is correct.
And you don't know the names or the backgrounds or the exposures of the people to whom those organs belonged, do you?
No, I don't.
And so you don't know whether, for example, the person from whom that lung with emphysema came was a smoker or a non-smoker exposed to environmental tobacco smoke, or a non-smoker not exposed to environmental tobacco smoke, do you?
Well, again, there's a three-part question. As far as emphysema goes, there's only one cause for emphysema to that degree, and that is exposure to cigarette smoke, whether it's primary or secondary. You'll never find a specimen from a non-smoker that has emphysema like that. So, no, I don't agree with the statement you made.
And with respect to the samples that you showed of the lung cancer, you don't know whether those came from a person who was a smoker or a non-smoker with or without environmental tobacco smoke, do you?
It's a generic example of lung cancer, and there is no physician, pathologist, anybody who could look at that specimen and tell you that that is that what type of lung cancer that is. That is lung cancer, however.
And you don't know whether the person who had it was a smoker or
That's
a
correct.
non-smoker.
I don't know that. It's just an example of lung cancer.
And you
Now,
don't know
again, 90% of lung cancers are related to cigarette smoke.
Sure. Now let's go back to the emphysema lung. And counsel, referring to page 131, line 21, referring to your deposition, doctor, in April, do you remember these questions being asked and these answers given by you? Question. Then I would really like to ask you questions about this one, if I could, before we go on to the next, without breaching any confidentiality. What can you tell us about the patient that this lung specimen came from? Answer. This lung specimen is merely an example of the disease process. This is a human lung specimen with emphysema. I do not have the name of this person or what his circumstances were. This is simply a demonstration of an example of emphysema. Question. Was this patient a smoker? Answer. All of these specimens are examples of the diseases that are caused by cigarette smoking. Whether this person was or was not, I don't know. I'm here to show you the diseases that we're talking about. Was this person exposed to environmental tobacco smoke? Again, this is the disease. The patient with this lung, I couldn't tell you, or these lungs. Were those questions asked of you and those answers given, doctor?
To my recollection, that's correct.
Thank you. Now,
That still does not negate the or contradict anything that I've said before. I just don't know who those lungs came from, and that was the.
And that's all I was asking.
And that was all the answer was directed to.
By the way, in your experience in doing transplants with lungs, putting lungs into people who needed a transplant, you use the lungs of smokers and non-smokers as well for transplants, don't you?
I certainly do.
Okay.
And let me clarify that.
Sure.
Organ donation in the United States is a voluntary process. And there are many reasons that organ donors die. In the United States, there are two major ones. One is gunshot wounds to the head, either self-inflicted or homicide, and traffic accidents. Now, many of those patients smoke and may have exposure to secondhand smoke, yet their lung function has not deteriorated to the point where we would then be transplanting a disease, a clinically significant disease, in these young patients. And most of these are young people in their 20s, maybe teens. A patient who is 50 years old, who is a smoker, I would not transplant their lung into a patient who needs a lung transplant, because I would be transplanting a disease process with that. So, yes, I do use lungs from donors who are smokers. However, as they age, as donors age, as people age and then become donors, then I may or may not use, generally do not use smoker lungs from say a 50-year-old smoker, because by that time in their life, their lungs are clinically destroyed for that purpose.
Thank you. You mentioned a few moments ago that there were several types of lung cancer, and I skipped it because we weren't talking about that then, but I do want to give you an opportunity to explain that. There are, in fact, many types of, or several types at least, of lung cancer, aren't there? Different cell types.
Yes, there are.
And those include squamous cell carcinoma or squamous cell cancer.
Yes.
That's the most common, isn't it?
Well, that's changing. Adenocarcinoma and squamous cell carcinoma, the ratio of those two have been changing over the years for, I'm not sure whatever reason, but squamous cell carcinoma in the past has been a very prevalent type of carcinoma. As of 1997, that may or may not be true. It's about even.
If we wanted to take, for example, the three most common types, that would be squamous cell, adenocarcinoma, and what, small cell carcinoma?
Probably large cell carcinoma.
Large cell.
But then there's small cell, there's bronchoalveolar, there's many other different types.
And all of the types of lung cancer that occur in smokers can also occur in non-smokers at lower percentages, but they can also occur in non-smokers, can't they?
They can. Very much less frequent, yes.
And science, neither science nor medicine, has learned the precise mechanism yet, have they, as to how those cancers occur?
Well, I think the actual chain of events that occurs is probably not known, but there are speculations and also evidences that chemicals found in environmental tobacco smoke, secondhand tobacco smoke, and in primary tobacco smoke cause mutations in cells of lung cancers.
Doctor, when we asked you at your deposition if you knew what it was in smoke that caused disease or how the disease was caused, you recall saying if you or anybody knew that, they'd be in Stockholm receiving a prize?
I certainly did say that, and I still hold to that.
And you meant by that the Nobel Prize in medicine, didn't you?
Yes, I did. It may not be in medicine, it may be in chemistry, but that still does not, I think that is still true. What I'm saying is the linkage towards that etiology is becoming better known, and one of these is genetic mutations of lung cancer specimens that have the exact chemical, benzpyrene specifically, on it, which mutates the p53 suppressor gene. Now,
that's ongoing research, isn't it?
No, well, I mean, sure, it's already research that's done, but I'm sure there's the NNK, all the other different types of carcinogens.
Yeah, I mean, aren't they engaging in ongoing research, trying to find out exactly what it is, what substance or substances cause lung cancer, and also exactly how?
Well, again, that's a several-part question. The how part, yes, you're right. There are a lot of research going on. The what part of that, as I was trying to explain, and let me finish, and I'd like to explain this a little bit better. The p53 suppressor gene is present in all of us. We all have this gene, and it tends to hold down cancers. It keeps our cells in check. I described to you the one cell that then starts dividing into many, many over and over and over again to create the lung cancer that you saw. And one of the genes in our chromosomes is the p53 tumor suppressor gene. And if that gene is intact, then incidences of cancers are less. If that gene is mutated in any way, then its function may not be as prevalent. In lung cancers, there are many, many mutations of that particular chromosome so that it would be ineffective in suppressing tumors. Now, that's a linkage between benzpyrene, a chromosome that's known to prevent cancer, its mutations to promote or allow cancer to happen, but the actual how all that happens, I don't know. And that is a part of ongoing research.
And science and medicine have not concluded that benzpyrene causes any lung cancer in humans yet. This is part of a theory that they're exploring. Isn't that a fair statement?
Well, you can interpret any way you want. My interpretation of the data that is out there in relation to benzpyrene and its effect on p53 tumor suppressor gene is that it causes it. Now, how it does that, yeah, there's a lot of research going on.
Are you telling the jury that that this study that you're referring to concludes that benzpyrene causes lung cancer in humans? Is that what you're telling the jury?
I'm telling you it is one of the factors. That study mentioned that there are many different chromosomal abnormalities or many different parts of that tumor suppressor gene that are affected by that molecule. And these were studies on populations of lung cancers. Now, to my way of thinking, that is pretty close to an etiological linkage, but that's not the total basis for determining that cigarette smoke causes lung cancer.
Oh, no, and I'm not suggesting that. I was asking you about the specific work you were just talking about. Now, when we're talking about this research that's going on, not just that work that you were talking about specifically there a moment ago, but the general concept of active research into what substance or substances may be the problem in cigarette smoke. The same thing is true with respect to environmental tobacco smoke, isn't it? That is, there's active ongoing research trying to figure out what it is in there that's the problem.
There's no question that cigarette smoke, whether it's primary or secondary, causes lung cancer. And now there's active research into exactly how that happens, certainly, but there's no question about the causality of it.
Maybe I didn't make my question clear, Doctor. Science doesn't know what the substance is or substances in environmental tobacco smoke that are the problem. And there's active research into what that is within environmental tobacco smoke. That's all I'm asking you. Is that true?
Basically, that's true. The cigarette smoke as a whole is the problem. It's not just one substance in there, as much as we'd like to figure that out.
And it may be that the same problem substance is in an ETS, or environmental tobacco smoke, that's in regular smoke, or it may be something different, right? We just don't know at this point.
That may be true.
Now, I think you believe, don't you, Doctor, that it is not appropriate in attempting to measure the amount of environmental tobacco smoke that somebody is exposed to do it by picking out one suspected carcinogen and tracing that.
Where do you get that statement?
From page 163 of your deposition. Line 2. Is it your point, Doctor, that in attempting to quantify environmental tobacco smoke exposure, we should attempt to do so by measuring agents that are thought to be related to the disease process of interest. Answer, just the opposite. Question, how is that? Answer, since nobody knows what the agents are that cause the disease process, if we start measuring one of those things, it may give a statistical association between the two. But to say that one causes the other would be unfair, because we don't know the cause of lung cancer or what it is in cigarette smoke that causes the emphysema. Cigarette smoke as an entity causes it. What it is in there is a matter of active research. And as far as I know, that factor has not been pinned down. And it may be many factors in the cigarette smoke, or one factor for one person and a different factor for another. The cigarette smoke itself is the problem.
Sounds good to me.
Me too. We're agreed on something.
I'm glad it was something I said.
Now, fair enough. I want to ask you about dose. Let me get the... I guess this... Now, I think this will... I think I right, so we'll be able to read it right. I see if we can agree on something else. You would accept this, wouldn't you, Doctor, that individuals have different thresholds for development of lung cancer? It takes more of the substance in one person than it does in another. It varies according to the person.
As a population of people exposed to cigarette smoke, if there was an ability to control the identical exposure over a population of people, for instance, we were all sitting in this room for 50 years, heaven forbid, together, and there was a smoking machine in the back, and then we'd all die out over the years. We'd all be exposed to the same cigarette smoke. We'd all die of various reasons. And so whether that's a threshold, it's a sensitivity, it's to try to confuse an individual's sensitivity with a population's group sensitivity we have to separate those things. So yes, maybe one individual is more susceptible or sensitive, but we're not necessarily talking about individuals here. We're talking about populations.
Okay.